This is Content Slam 1 for family law, for the first part of the family law topic, the nature of family. The first thing the syllabus asks you to do is discuss the difficulty in defining family. To do that, we need to talk about the concept of family. We also need to talk about alternative family arrangements. So the concept of family is traditionally focused on a nuclear family. However, and the law continues to favour these types of families. However, there are a variety of alternative family relationships which do exist. That includes Indigenous and Torres Strait Islander, single parent, de facto, same-sex, and polygamist. Now, these groups are essentially not fully recognised. However, they will in some areas. So marriage is not recognised for Indigenous people because it is not written down. That's pursuant to the Marriages Act, the requirements set there. That was first held in R and Neddy Monkey 1861. However, pursuant to Section 61 of the Family Law Act, it will be considered when determining care for children. Single parents do have some protection. They're now protected under the Child Support Scheme. They no longer have to go to court to have their partner who's not living there pay for them. That was brought in under the Child Support Registration and Collection Act 1988. That's administered through the Department of Human Services, which is essentially Centrelink. The de facto people is set out in New South Wales legislation. That's for people who live together for 2 years. It may be shorter than that if you have children, you're caring for children, or under other circumstances. Same-sex people can be included as a de facto relationship. That is set out under the Property Relationships Act 1984, New South Wales. It is also covered under Section 4AA of the Family Law Act. Same-sex people cannot be married. They are recognised as de facto, but that cannot be married. That is pursuant to Section 5 of the Marriages Act, and that was officially brought in by the Howard government in 2004. However, there have been improvements. 84 amendments in the Same-Sex Relationships, Equal Treatment in Commonwealth Law's General Law Reform Act reformed 84 pieces of legislation to make it more equitable and fair for same-sex people. Polygamous relationships are not permitted. That's pursuant to the definition of marriage set out in Hyde and Woodmansey, since copied into Section 5 of the Family Law Act. However, it will be considered during separation and property settlement and how to deal with children. Okay, now the next thing we have to look at is distinguishing between state and federal jurisdiction. Federal law is the area that federal looks after family is set out under Section 51 of the Constitution. Specifically, Section 21 deals with marriage and Section 22 deals with divorce. So that means that they've passed two sets of laws, the Marriages Act 1961 and the Family Law Act 1975, that covers both those powers. That means it has power to deal with divorce, marriage, parenting, asset splits, and domestic violence in some sense. However, that's also under state law, which we'll discover. State law, on the other hand, deals with de facto relationships under the Property Relationships Act, adoptions under the Adoptions Act, children, care and protection of Children Protection Act, and domestic violence. Again, you'll notice that's dealt with in two areas under the Family Law Act. That shouldn't be the Family Law Act. That shouldn't be there. Crimes and Domestic Personal Violence Act. That's where it's dealt with. So every family issue is dealt with in the family court. All the state issues are dealt with at the state Supreme Court. Okay, moving on. The requirements of a legal marriage. So under Section 5 of the Marriages Act, a marriage is defined as a union between a man and a woman entered into life with the exclusion of all others. This was inserted by the Howard government, as mentioned before, in the Marriage Amendments Act 2004. This follows the definition of Hyde and Woodmansey 1866. In order to have a valid marriage, people must give notice of the marriage somewhere between 1 month and 1 day and 18 months, pursuant to Section 42. There must also be 2 witnesses required at that ceremony, pursuant to Section 44. The age must be 18 years, pursuant to Section 11. However, 16 years and above can be permitted to marry with court approval under exceptional circumstances, pursuant to Section 12. There must be a certificate lodged with the birth, deaths and marriages within 14 days of the marriage taking place, pursuant to Section 50. Prohibited marriages under Section 23 include people who are already married, consent is not freely given to the marriage, parents could not marry their children, and brothers and sisters may not marry half or full blood. There is a media study on this which we've covered, the Sydney Morning Herald, March 2005, where a man consents for a 12-year-old daughter to be married. Our last section now, the legal rights and obligations of parents. Under international law, the Convention on the Rights of the Child is really important, and Australia has adopted that. So Article 3 of CROC says that we must look to the best interest of the child. Now, that has been reflected in Part 7 of the Family Law Act. Article 12 says child should be supported or should be allowed to express their views. That's reflected in Section 60cc of the Family Law Act. Other responsibilities that parents has, they must send you to school or send someone to school until they're 17 years of age. That is pursuant to the Education Act. That's a New South Wales Act, Section 22. If they fail to do that, they can be fined between $10 and $2,000. Healthcare, 14-year-olds can start to look after their own health after they've turned 14 pursuant to the Minors Property and Contracts Act. Failure to provide for somebody's healthcare below 14 years of age or preventing someone over 14 years of age can result in 5 years in prison or up to $22,000 in a fine. Discipline, that centers around what is reasonable force, and the parent must give consideration to the age, maturity, and other things associated with that child. That's pursuant to Section 61 of the Crimes Act. Parents may not neglect their child in terms of hygiene, food, and emotional support. That's pursuant to Children and Young Persons Care and Protection Act. If they fail to in this area, the Department of Community Services may step in and may remove the child. Adoption is also part of this. Someone can become a legal guardian even though they didn't give birth to you, and have the same rights mentioned above, even though they didn't give birth to you, through the adoption process. In order to adopt somebody, you must consult the Adoption Act 2000, New South Wales. There must be consent. First of all, from the biological parent. There must be a consent from the adopting parents. And if the child's over 12 years of age, they must also consent. There is an important media study of this regarding Deborah Lee Furness, which is Hugh Jackman's wife, who's campaigning to improve international adoption in Australia. This article provides a range of statistics and outlines some of the problems. That is the entire third of the course that you need to know. By reviewing this, you have come a long way in understanding this topic.